My name is Joshua Bengal. I am the Government Relations Director and in-house lawyer for the Medical Society. Thank you very much for coming tonight. And if you're listening to this recording subsequently, thank you for listening and for your interest in MSNJ. Um, so I guess before I jump into this slide, which is about one of our legislative achievements, I should explain that generally MSNJ serves a lot of functions and is many things to many people. And that is one of the great aspects of MSNJ that we cover a lot of ground. I like New Jersey, we are small but mighty. But as you can imagine, and as you've probably heard or learned, legislative advocacy is one of the most important aspects of what the Medical Society pursues each year, and certainly in the last 2 years since I joined MSNJ. Um, about 2 years ago, when I first came on board, we went through the process with our board of trustees, our executive committee, and even our council on legislation. So a really good cross section of the leadership of the Medical Society. We went through the process of establishing what our legislative priorities would be. And because we are a medical society that is an umbrella organization and has members that come from all of the different specialties and subspecialties within the practice of medicine, and because all of our physicians come from the northernmost part of the state, the tip of Bergen County, all the way down to Cape May County, and because our members come from the smallest practices, single physician practices, all the way up to some of the biggest practices in the state, like Summit Health or now Village Healthcare. For these reasons, it's very important that we have not only a targeted set of priorities, but a broad set of priorities that captures all of these diverse and important interests. So through that process of establishing what our priorities would be, one of the top issues that kept coming to light was prior authorization. Prior authorization, as I'm sure you know even better than I do, prior authorization is a nefarious process that insurance companies use to essentially stand in the way of care between a physician on the one hand and the patient who needs that care. Um, we heard time and again that prior authorization was not only interfering with care and with the ability to run a practice, but was really causing really a whole slew of problems for physicians practicing in the state, leading to wide-ranging effects such as physician burnout. Um, and physician burnout is a really broad, problematic issue that spans really the entire country. And when you have something like prior authorization that, as we found, is a really significant part of what causes that burnout, then it's pretty clear that you got to go right to the source. You got to try at least to solve the problems that you've got. And prior authorization was one of those problems. And so we introduced or reintroduced at the beginning of that session an old bill that would reform the prior authorization process for New Jersey regulated health plans. Now, there had been a law that was passed and signed into law by the governor in 2005, regulating prior authorization processes imposed by insurers. That law was not nearly tight enough. Well, it may have been. It was a little bit before my time, not practicing, but it was before my time representing physicians. So I don't know whether it was an appropriately tailored law in 2005. But what I do know is that by 2022, it was no longer sufficient to ensure that physicians weren't going to suffer through the prior authorization process and that patients weren't going to suffer right along with them. And so what we did was we took a prior authorization bill that had been reintroduced in each legislative session over the last for 6 years, I guess, because keep in mind legislative sessions are 2 years apiece. Um, and we really did an overhaul. We looked at all of the specific problems that physicians were having. We looked at some of the best models that we could find from across the country, including ones that we identified with the help from our partners at the AMA, with whom we work very closely. And we made that bill the absolute best bill and really the most aggressive bill that we could possibly make it. And over the next 2 years or so, because it really started at the very beginning of the 22-23 legislative session, over the next 2 years, we advanced that bill slowly but surely through the legislative process. And this is the process that you may remember from the Schoolhouse Rock cartoons. You know, I'm just a bill on Capitol Hill. So that process is lengthy. And in the process, there are many, many hands in the pot. I was told by my mentor, there are two things you don't want to see made, sausage and legislation, and that all the sausage makers get really insulted when they find out they're being compared to legislators. But this was the process that we engaged in. And we advanced the bill through committee after committee after committee in both houses, the Assembly and the Senate. And then we got the governor's office on board. All the while, we were negotiating against and doing battle with the insurance industry, fighting quite hard to ensure that our interests were heard loud and clear in the legislature, on the floor of the legislature, and in the governor's office, and to ensure that the insurance industry wasn't able to squeeze out the serious concerns that we had about prior authorization. So in the end, just recently, just in early January of this year, at the tail end of the 22-23 legislative session, that bill was signed into law. And it goes into effect in January of 25. And it'll make some important changes to the original 2005 law, really tightening up restrictions on insurance companies in the prior authorization context. So, for example, the original 2005 law required decisions to be made on prior authorization requests within 15 days. And as you can imagine, you'd get to day 14 plenty of the time, and the insurance company would say, oh, no, sorry, you didn't send us all of the information that's required. And then you would supply that information, and then they would take another 15 days. So you could have some pretty extended periods when you wouldn't have a decision on prior authorization. Our new law brings that 15-day limit down substantially in many cases, especially for medications and especially for urgent care that is needed by the patient on an urgent basis, not quite emergency room or emergency department requirements. But if you need an urgent decision that doesn't quite rise to the level of ED referral, the insurance companies will have as little as 24 hours to make decisions on those prior authorization requests. So that was a really significant win and a big change from the law from 2005, but it's not the only one. It's not the only change. We also were able to get improved access to peer-to-peer conversations for really all physicians in the state. One of the concerns we kept hearing, or the issues we kept hearing about, was that physicians would prescribe care, they would find out that they had to go through the prior authorization process, and then care would be denied. And then the physician would call the insurance company and would say, why are you denying this? This drug that I prescribed or this testing that I prescribed is absolutely the standard of care. And the person on the other end, employed by the insurance company, would say, oh, no, I'm actually reading from my playbook here, and it says that you can't have that. And the physician would say, what are you talking about? I was instrumental in developing the standard of care, and I wrote papers on this. It's very clear that what I'm prescribing is absolutely necessary for the patient. And the person from the insurance company would say, sorry, that's not what I have in my booklet here. I'm not allowed to approve that. So what we implemented was a requirement that a physician has a guaranteed peer-to-peer right on all appeals to speak with a peer physician who is in the same or similar specialty, or who has actual experience treating the condition at issue. And it's our anticipation that that is going to change the experience for physicians in a positive way, so that when they do have to go through prior authorization processes, the process happens much faster, and it's a much more logical process where the physician has the ability to talk to someone on the other end who actually knows what's what. And finally, this was one of the hardest fought areas in our prior authorization discussions, really over that 2-year period. It's one of the aspects we wanted the most, and one of the aspects that was pushed back hardest on. We attempted to essentially to eliminate prior authorization for chronic but well-controlled conditions, on the theory that, if you need blood pressure medication, how often do you ever not need blood pressure medication in the future? If you need cholesterol medication, how often does that requirement go away? It doesn't. And therefore, there shouldn't be a prior authorization for a drug that you've been on, that you've been well controlled with. Unfortunately, that was as I said, one of the hardest fought areas. And so we were able to get a 6-month limitation on prior authorizations for controlled chronic conditions, and multi-part treatments, such as, a course of physical therapy or a course of psychotherapy with a psychiatrist. So I would say that that area was a win. It's a partial win, and it's something that once the bill is implemented, we can look and see at how it's being implemented, whether it is making a positive difference for physicians. And if not, we can go back and seek another bite at the apple, essentially. And as we seek another bite at the apple, which I think, eventually will have to happen, as it always does in legislation, the transparency, this last bullet, is going to be very helpful, because there is a lot of data that insurance companies sit on. They do not allow anyone outside of the company, whatever specific company we're talking about, and maybe the industry, to see a lot of their prior authorization data. That is no more. Now, insurance companies will be required to make public a lot of that data that will allow us, the public and public interest groups, and the medical society, to analyze and publicize whether the insurance companies are behaving in some way that is contrary to public policy. And we anticipate that we're going to find some evidence of that, and we will bring it to light. So that was a pretty significant win for the medical society, and a great example of what we can achieve when we all come together. All of the many, many thousands of physicians in the state coming together in a society form that has the ability to go out and advocate legislatively, and to build coalitions. And I must admit that there were many other partners that we had, ranging from grassroots physician groups, patient advocacy groups, the specialty societies, specialty physician societies at both the state and national level, and of course the AMA, as our really, very consistent, never-ending partner. But that is why we are here, in order to build these coalitions and advance these important causes. Another great example of some of the advocacy that we pursued, and in this case succeeded on, is telemedicine pay parity. Telemedicine was explicitly permitted by law in New Jersey in 2017. But I remember asking my own physician, probably in 2018 or 2019, do you offer services via telemedicine? And the physician said, no, the systems aren't really in place. The reimbursement structures aren't really in place. No one's really doing it. Fast forward to March of 2020, just about 4 years ago now. And as we all know, things changed very quickly. Telemedicine became a tremendous part of what, maybe not all, but many physicians in the state practice day to day. And the medical society around that time, in that first 6 month period, was instrumental in establishing the first telemedicine pay parity requirement by law, which meant that any service that's reimbursed at a certain level when it's performed in person needs to be reimbursed at the same level when performed via telemedicine. That requirement was time limited, and it was set to expire in December of 2023. And so you can imagine, with significant opposition from the insurance companies, we fought tooth and nail to get that telemedicine pay parity extended beyond December of 2023. We, of course, sought a permanent extension. We didn't get everything that we sought. In the end, we got a 1 year extension through the end of 2024. Largely in part, or largely so that the Department of Health can return a study on the effects of telemedicine and the effects of telemedicine pay parity. We expect that study to come out probably within the next month or two. And we anticipate that that study will help us with our advocacy going forward, something that I'm not really addressing so much in this talk, but I likely will in future talks. That study will help us with our advocacy going forward on making that telemedicine pay parity requirement permanent, because that's really where this needs to go. There's no reason to think that that telemedicine is going away any more than it has in the last year or so. And telemedicine pay parity is what ensures great access to care for a large percentage of the population, including some of our most vulnerable residents, who, for one reason or another, and there are many, cannot make it to in-person physician appointments. So another big win, again, like many, a partial win, but a significant one, and one that will lead into, or has led into, our legislative priorities going forward. All right, next up, and I should add that this is really just a selection of the work that we did over the last 1.5 to 2 years. So if you want more detail about some of these legislative wins, feel free to reach out to me. I'm happy to talk about all the work that we've done, all the work that we're doing. But this is a good selection that sort of shows the breadth and the significance of the work that we do. So virtual credit cards. You may have experienced these. Insurance companies pay physicians by what is known as virtual credit card. It's essentially, it's functionally a credit card that the physician needs to run through their merchant terminal that they, in practice, it's something, a patient will come in and pay their copay, their $20 copay, let's say, at the merchant terminal on the physician front desk. And that merchant terminal that transaction is always associated with a merchant terminal fee. It's not, I guess, really all that big a deal. It's not great, but it's not all that big a deal when we're talking about $20 copays from patients. It's very significant when we are talking about payments from insurance companies for those bulk payments representing the bulk of the care that was provided to each patient. It means that the insurance company has essentially transferred its administrative costs in paying physicians onto the physician. And then it's also likely that those insurance companies are entering into very lucrative deals with the virtual credit card companies, who are taking a significant cut of that merchant terminal fee. And so we were able to work with, again, partners in all these areas of advocacy. We were able to work with our partners over at the Dental Society, um, to pass a law, have it signed by the governor, a law that ensures that virtual credit cards will not be the only method of payment that a physician is able to receive from an insurer. So just another example of the wide breadth of the work that we do to fight for our physicians, and to ensure that they're able to keep their practices open and that they're able to keep treating their patients, providing high quality medicine. So those are some of the legislative wins. But as you can imagine, the legislative process is a political one. And politics is very often a gist, a gestalt kind of thing. You have to take a very long view type approach to politics, because political lives are long, political careers are long, and political memories are long. And so this leads into the connections that we have built in the New Jersey legislature. For many years, decades now, there has been one physician in the New Jersey legislature, and that is Herb Conaway, a longtime friend, very close friend of the Medical Society, longtime member and very close friend, someone whom we've collaborated with on countless bills over the decades. He is the chair of the Assembly Health Committee, and he is an influential legislator. But there are 120 legislators in the New Jersey legislature, and Dr. Conaway, Chairman Conaway, is just one. And so when we learned, and a lot of, you'll find that a lot of politics is reading which way the wind is blowing and then taking advantage of that direction and capitalizing and maximizing the positive gain. So when we learned that there were two potential candidates for assembly seats in their districts in New Jersey who were physicians, we were very excited, and we threw our weight behind them full force, and very early on. And those two candidates were both elected, and they are now sitting assembly people. They are both on the Assembly Health Committee, working with Dr. Conaway. I actually just saw both of them this morning in Trenton at the State House. The first is John Azariti, a physician up in the 40th district, way up north in New Jersey. He is an anesthesiologist. And the other physician is Margie Donlin, a physiatrist in the 11th district, which is down by the shore. Her co-district mates are Vin Gopal, who is not a physician, but I believe both of his parents are physicians, and is another close friend of the Medical Society. So that 11th district is a very important one to the Medical Society, and we are pleased to support not only Dr. Donlin, Dr. Azariti, and Dr. Conaway, but also Vin, who actually was our Legislator of the Year awardee last year, and was actually the sponsor of our prior authorization law. And so you can see how we are taking the long view and building coalitions, not only of other associations and patient groups, but also really investing in the future of the legislature itself by ensuring that people who have our interests at heart have success in the legislature in their own right. So we're excited to work with them going forward. This is especially relevant because Herb Conaway is actually running for Congress right now. He's running for the seat that has been vacated by Andy Kim. And we are hopeful that he will win his election, and he will go represent us in Washington. We are very sad to see him go because he is, as I said, a tremendously valuable partner in Trenton. But we are very excited to have him, to see him advancing in the way he has. So, so I've now shared a lot of a lot of the political and legislative wins and efforts at MSNJ. But that's not, as I've said before, that is just a small portion of the overall work that we are doing. Horizon Modifier 25 payment cuts. These are really a pernicious attempt by insurers, in this case Horizon, to reduce payments to physicians and to practices unilaterally. Really likely often in violation of contract, but certainly in violation of good public policy. And so through both legislation, we have a bill that would essentially create a review commission in the Department of Banking and Insurance, where anytime an insurance company wants to make an across-the-board cut like this, like the Modifier 25 payment cuts, they would have to get approval from that commission, that New Jersey commission. But in addition to those efforts, you can imagine we are frequently reaching out to Horizon, and in many other contexts to all of the insurance company representatives who we have connections with at the insurance companies across the state. So Horizon, Aetna, United Health Group. This is just, sort of this Modifier 25 pay cut work that we are doing is just one small example of the efforts that we make day in, day out, to combat abusive insurance practices. And more to come on this. This bill, we introduced it at the end of the last legislative session, a sort of a shot across the bow to the insurance companies so that they knew we were fighting back on their payment cuts. And I think there's going to be more to come in the near future in this legislative session. So stay tuned for more. And then in addition to our legislative and sort of business type advocacy, like those phone calls that we make day in, day out to our, I'll say, adversaries at the insurance companies, we also take similar steps to represent physicians in court. The principal way that we do this is through our ability to serve as an amicus. So an amicus is sort of a quirk of the legal system. An amicus curiae is a brief that is essentially submitted. It translates roughly to a friend of the court. And the idea is that in just about any dispute, you generally have two or more competing parties, a plaintiff and a defendant, or plaintiffs and defendants. But often the court would benefit from having almost a third party, maybe a somewhat neutral, but a wise third party chiming in on the import of a case. And that third party can provide expertise and reflection that the parties to the case, because they not only are they opposed, but because their interests are so fixed, they cannot provide that perspective. And so the medical society frequently gets involved, again, as partners with the American Medical Association and their litigation center. We get involved in litigation in that amicus context. So the first case that I want to mention is the Michela case. In the Michela case, a plaintiff, a pro se plaintiff, so a plaintiff who is not represented by an attorney, attempted to bring a medical malpractice action against a physician. In New Jersey, there is a requirement that any malpractice action needs to be supported by what's called an affidavit of merit. And that is a document that is signed and certified by a licensee who is of the same type as the person who is being sued. So, for example, if a plaintiff wants to bring a lawsuit against a physician, they need to have an affidavit of merit signed by another physician. If they want to sue a nurse, they need to have an affidavit of merit signed by a nurse. In this case, the plaintiff brought an action against a physician, but did not ever get an affidavit of merit that complied with all of the statutory requirements, including the significant requirement that that it be a physician who signs the affidavit of merit, and also that the physician engage in an in-depth review of the specific facts of that case. So the plaintiff provided a number of documents that purported to be affidavits of merit, but in each case, there was something that was critically infirm about that document. Either it was submitted by a nurse, it was submitted by a physician, but the physician hadn't actually reviewed the facts of the case directly and was speaking only to the general standard of care, this type of issue. And so when we recognized that this case, which we thought really should be an open and shut case where the court would say, nope, the affidavit of merit statute is very clear, you have not complied with it, your case is dismissed. When we found that this case was going to the New Jersey Supreme Court, which has the authority to make widespread law, essentially established law through its case deciding procedures, we determined that it was important for us to get involved. And so we have submitted a brief that argues that the integrity of the affidavit of merit statute must be maintained. And we are awaiting a hearing date when we will likely engage in oral argument before the Supreme Court. So as with the Modifier 25 work that we're doing, stay tuned for more because there will be an update in the near future. The next case that we are working on concerns the Patient Safety Act. This is the Bender case. In New Jersey, there is a law, the Patient Safety Act, that essentially protects from discovery self-critical analysis that is done by, say, a healthcare facility or a healthcare clinician. So when something happens to, when something goes wrong in a patient treatment, there's a recognition that a facility or a clinician should have the ability to make that self-critical analysis, but not be required to turn over the results of that analysis in subsequent litigation. And the reason for this is obvious. We want to encourage, not discourage, self-critical analysis because it's how we improve, it's how we ensure high quality care going forward. Just recently, in this Bender case, which was actually consolidated with another, so you may see it in the future under the name Keyworth. In this consolidated case, the plaintiffs in the matters have sought access to these self-critical analysis documents. And we've actually, the protective position for that self-critical analysis documents, that is actually the position that has prevailed at each level through the appeals process. So it wasn't really our case because we hadn't gotten involved yet, but our position was the one that prevailed at the intermediate appellate court. But now the case is going up to the New Jersey Supreme Court, which again has the ability to make widespread legal decisions that apply in all other cases going forward. So for that reason, we decided that this was a case that we should get involved in, and we have submitted an amicus brief. Stay tuned again for more information on this one. And then finally, the comprehensive neurosurgical versus Valley case. This is a great example of an instance where the medical society is really needed as an advocate for physicians, because even when they are adverse to their own hospitals, because without the medical society, there simply is no one else to advocate for the physicians or on the physician's behalf. In this case, the comprehensive neurosurgical practice was established at Valley, and engaged in essentially providing high quality care to the remunerative benefit of the hospital for many years. But over time, Valley started to compete with a nearby hospital where the comprehensive group was also practicing. And in a classic and ugly case of turf warfare, the Valley Hospital decided to essentially close out comprehensive from its ability to practice at Valley by revoking the privileges of all of the physicians who worked for that practice group. Um, Hospital privileging is it's treated as almost a sacred process in New Jersey, because there is a longstanding legal recognition that in order for patients to have quality or good access to high quality care, those physicians need to be able to obtain privileges at nearby hospitals. And so when the Valley Hospital took this privileging action against all of the physicians at Comprehensive, they recognized, and this is what we argue in our amicus brief. They recognized that they were not going to be able to meet that high burden. That if you really just looked at the legitimate elements of the analysis, the comprehensive group was going to be able to keep practicing at Valley. And for business reasons, Valley didn't want that. And so they essentially falsified aspects of their privileging review process in order to revoke the privileges of the physicians. This resulted in litigation, which was then appealed. And now, again, as it goes up to the New Jersey Supreme Court, this is where the medical society has determined we've got to get involved and we have to fight for physician interests in this case. And so this is another case that I encourage you to stay on top of. We will be releasing information as all of these cases develop through eNews, which is really a tremendously valuable newsletter that we offer just as part of the membership to all members of the medical society. So stay tuned for we think pretty important and we hope positive developments in all three of these cases. I'll mention this case very briefly. It's in many ways one of the most complicated, but rest assured, in actions where insurance companies, in this case Cigna, have underpaid physicians in violation of contracts that those physicians entered into over the course of many years. We've actually joined in as a named plaintiff. So the name of the case, if you want to Google it, is AMA versus Cigna. But the Medical Society of New Jersey is a named plaintiff along with the Washington State Medical Association. So I'll say a little bit less about this. I don't want to go into too much confidential information, but it's another great example of the medical society fighting for physician rights. And so I will actually ask, is Larry
I am
is
on.
welcome, Larry. This is where I will turn it over to Larry, who I know wants to mention our annual meeting, which is coming up very soon. For those of you who don't know, Larry is our CEO, has been our CEO for a good number of years. And yeah, without further ado, I'll turn it over to Larry Downs.
Thanks, Josh, and really nice job summarizing those legal cases. And again, the last case Josh mentioned, the AMA v. Cigna. That's one that's in discovery right now. We actually have meetings coming up this week and next week, I think, with the lawyers handling that case. We're going to learn a lot about how these companies work with kind of phantom networks or networks that exist in name only, and they buy and sell rates. So even if we don't prevail, we're going to learn a tremendous amount through discovery about these processes. So as Josh said, stay tuned on that. Like every law case, it takes a fair amount of time to turn the wheels of justice. So, but let me take us through the last part of our lecture here. I just wanted to make sure that we put out some information in terms of the annual meeting, how you get involved in it, how you take ideas or issues that you encounter in your medical practice and bring them to the attention of the State Medical Society or the AMA so that we can work on them. On your screen, you'll see that Friday, April 19th, and Saturday, April 20th is our House of Delegates. We do this. This is a kind of the annual shareholders meeting, I guess, of the Medical Society. All the members are invited. There are delegates selected from all of the county medical societies that come to New Brunswick and elect our new slate of officers, consider resolutions that have been submitted all resolutions are simply ideas encapsulated in a kind of formalistic style. And they review these resolutions, and some of them, for instance, might ask the medical society to take a position on a certain issue, or they may request that the medical society reach out to a state agency to engage in a problem, public health or otherwise, that the MSNJ can have an impact on. The resolution may ask MSNJ's AMA delegation to bring a resolution to the AMA meeting, either at the annual meeting in June or the interim meeting in November. So there's a number of ways that ideas can get to the attention of the organization. I mean, it's fine to pick up the phone and call Josh or me or one of the staff, but if you want to engage the entire organization on your issue, the proper way to do it is to submit a resolution, and those are considered throughout the year. We have 4 or 5 opportunities where people can submit resolutions to the organization, and one of those times is at our annual conference. We actually do conduct resolution writing workshops from time to time to help people kind of put their ideas down in a format that we can act on. And we'll be scheduling another one of those later this year, probably after the deadline for resolutions for the annual meeting. But if you're interested in attending and kind of seeing the resolutions, I recommend you join us on April 20th. We're going to start the day from early, 8 to 10 or so, with a great CME presentation by our very active JEDI committee. That stands for Justice, Equity, Diversity, and Inclusion. And Camille Green has put together a really nice educational program on equitable maternal care and paving the way to healthcare excellence in that particular area. Certainly an area of concern for everyone in medicine in terms of the poor outcomes that we're getting in maternal care in our state. And then we'll also have a great national perspective delivered by Sandra Freihofer. Dr. Freihofer is the immediate past board chair at the AMA. And she's graciously agreed to join us, and will be giving the perspective of issues that are important to doctors across the nation. And so we're so happy to have her join with us. On the Friday night prior to the annual meeting, we have a great Capital Club reception. One of the things, I don't know if Josh touched on it earlier, but we maintain a very active political action committee, which helps elect friends of medicine to the legislature, so we can get the best possible policies to benefit patients and physicians in our state. And we do a fundraiser and a reception on Friday before. It's at the Stage Left Steakhouse right in New Brunswick, almost directly across the street from the Heldrich. So that's always something I would commend you to join. And then we'll move into the Saturday program early on Saturday with the CME, and then on to the resolutions and our elections and things like that. So I just wanted to make sure that folks knew, how to enter a resolution. If you are interested at all in serving on reference committees, the JEDI committee, our climate task force, any area that we have, certainly just a reach out to Josh or myself or the staff office, and we will alert our president, who can make appointments to any of those